The final matter to come before us this morning is Groom versus State of Ohio. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve that time, if you let me know when you get started, I'm keeping the clock this morning. We have read the briefs and we are ready to proceed when you are.
Thank you, Your Honor. Rick Bettini on behalf of Mr. Groom, may it please the court. 3 minutes will be fine. I may reserve. This is a sex offender registration case that presents some issues with respect to every state has the right to have their own laws that are separate and distinct from other laws, and we have sex offenders now that are traveling more frequently between states, and what we're having is trying to mesh one state's laws with other states' laws. In this case, he was convicted in 2006 with what would be the inappropriate touching of some clients as a masseuse. I guess the important part of that statute would be the sexual contact portion of that statute. We flip it over. He moves after he's done with his requirements there. He moves to Ohio. He registers for a few years as sexually oriented offender, what would now be Tier 1. At some point subsequent thereto, the Attorney General's office sends out and says, you are now a sexual predator. And when you go back and look at the Colorado law, it is an open-ended type registration. It says you have to register for life, but in 10 years you can come back and you can petition us to potentially remove that.
So it was a minimum of 10 years?
Yes. And that would be, I believe, from 2008, April of 2000, because it's 10 years from the date of his final registration requirement, or the date of his final release from the court, which would be April of 08. So sometime April of 18 would be when he could potentially petition that court to modify it. There are other factors in that the Colorado law that say that certain things are not, you cannot come back at a later point. This is not one of those cases you can come back. So when he comes to Ohio and you look at the relevant conduct and you say it would be sufficient to what we would say here as sexual imposition, and I believe that we stipulated to that at the trial court level. The question would then be, is he eligible here if it's substantially similar conduct to what we would see as sexually oriented offender? Is he then able to have that registration requirement here? And if he is not, then would the court hold a hearing to determine whether the sexual predator classifications are no longer necessary?
When you say no longer necessary, what do you mean?
The 2950.09, if you file a petition to say that you are not at likely risk, to reoffend, and that the court has concluded that whatever factors it deemed to label you as a predator, it could, under the old law, it could remove those. We don't have that now.
So they can't remove?
Well, Tier 3 you can't, but back then you could.
So you're saying because back then you could, that
petitioned,
carries over to now?
So we petitioned under the old law. We had a hearing in the trial court. Actually, he had completed sex offender registration. He had completed his probation, parole, whatever it was determined to be in Colorado, had completed it here, had completed any and all treatment, was deemed the lowest possible level risk to reoffend. We had a new study done 2 years later because he hadn't had any sex offender treatment because he was released. But to supplement the record, we had a new hearing. We had the same person conduct the same tests at the time of this case, and we presented that in the form of testimony. And it would be our position that he is the lowest level risk to reoffend. He has not committed any prior offenses that would increase any likelihood, and therefore the trial court could have, had they chose to remove those registration requirements. I understand that the state of Ohio's argument is that the doctor who testified could not guarantee that he would not be any risk to reoffend. I agree. I don't know that anybody could.
Does he still have the ability to apply in Colorado after 10 years to have it removed?
Yes, I believe that he still has I believe if we are unsuccessful here, I believe that he's going to have to go back to Colorado at some point and say, okay, Colorado, your laws, I believe, and whether he needs to establish some contact there with respect to residency to then, I'm not sure. I tried to brush up as best I could on Colorado law, but I don't believe that he would be precluded there, but I don't know for sure.
Well, hypothetically, if he did go back to Colorado and it was removed from there, isn't it the basis for it here?
Yeah, he could go back. Yes, it's difficult that, to be frank, when you're sending out registration requirements and they're trying to do some charitable work in the area, it's embarrassing, it's inconvenient, it's all those things that it's probably designed to be. So I guess, yes, he could wait another 3 years and go back to Colorado, or he could petition the courts here to apply the laws that we have here and we believe could be that the court could have made those findings. Now, the second issue with that is I had filed a request for finding. The entry just said denied after a year. When we ran the hearing, we got an entry back and it just said denied. I did file a request for findings of fact and conclusions of law, and I understand what happened now that I review it. It was filed in the correct case number. I believe what happened was...
It was filed in the incorrect case number?
The correct case number. However, it did not have CV in front of it. So when I filed it at the civil clerk's desk, they accepted it for filing. I thought that they had forwarded it to the state of Ohio. They hadn't. I asked this morning and they said, oh, we realized the error, we'll correct it. I don't know that corrects it in time for here. I would assume that even if I say that the trial court didn't include the findings of fact and conclusions of law, at some point I could request that it go back for those findings of fact and conclusions of law, which I would then be back right up in front of you potentially again and argue an abuse of discretion standard, and we would likely be where we are here. But I do believe that he has enough evidence that's been presented that he could be classified as a section-oriented offender, and we'd ask that it be reversed accordingly. If there are no questions, I will be finished with this portion of the argument.
Marvin Evans with the prosecutor's office for Summit County, representing the state of Ohio in this case. If it may please the court, I'm just going to be very brief. The state believes that Mr. Groom was afforded the due process that he was entitled to under the law, under Megan's law as it stood at the time. This is a very confusing area of law because of the Adam Walsh Act.
You say at the time he came to Ohio.
At the time of his conviction, I believe that's
and he was assigned sexual predator, but wanted sexually oriented offense.
Correct. We believe that because of the time of his conviction, which I believe was 2006, Megan's law was in effect.
Still in effect.
Correct.
So he is not correct when he says Megan's law back then should not apply.
Megan's law should apply. Right, because of the time of his conviction, Megan's law was what was in effect.
Well, under Megan's law, what would his classification have been?
If he were convicted in Ohio, I believe that Mr. Patini is probably correct. He would have had a lower classification. I don't know what that classification would have necessarily been, but I believe it would have been lower. But the way Megan's law was written, and I believe that both parties may have included the old law because it's frankly a little bit difficult to find, was that an out-of-state person is essentially held to basically a higher standard. And there was case law with respect to that, which was cited in the state's brief, which was State versus Reynolds, which kind of acknowledged that a person coming in from out of state.
You say kind of, and that acknowledged.
Well, the court acknowledged that in State versus Reynolds, that the person would be held to be a sexual predator until his due process to have a hearing
So he would
confirmed
be
that.
automatically categorized as a sexual predator, and then he would have some right to a hearing to reduce his classification to sexually oriented offender.
That's correct.
On what grounds would he be permitted to do that?
On a showing by clear and convincing evidence that he is not a sexual predator as it was defined at that time, which
At what time and where?
under Megan's law.
Okay.
Right, we're always referring to Megan's law, which was in effect, I believe, before January 1st of 2008, when Adam Walsh became effective, and then, as hopefully you're aware, that the Bodike case said that there were parts of that were unconstitutional. So the state believes that Mr. Groom was properly classified under that law as it stood under at the time of when Megan's law was in effect. He was given his due process hearing to put forth his evidence to have his classification reduced. The court had discretion to reduce it or not reduce it. I understand Mr. Groom's argument as to having no real analysis by the trial court judge, but there was obviously some type of an error in filing for getting clarification from the court, which Mr. Patini just referred to. And again, the state did not receive that filing, so we were never aware of it.
With respect to the clear and convincing evidence issue, there are professionals that say he's at a very low risk of reoffending, and the state seems to say because you can't say he absolutely won't reoffend ever again. What was the actual testimony? It sounds kind of contrite to say as long as someone's living, we,
Yeah, I guess I can't tell you verbatim certainly what the testimony was. Certainly I believe that the doctor that, or I think it was a private PhD, I guess, I don't recall, I'm sure testified that he was at low risk. The state, I guess we don't really take a position on that. That was for the trial court to make their own determination.
So you're saying the court had discretion whether to factor in the expert's opinion or
Yes.
not?
Yes, I believe that the court had discretion. I mean, that's how the statute was written. It was discretionary to the court. It certainly said the court may make that determination on clear and convincing evidence.
Does the record show that the court engaged in any analysis, sort of balancing what the expert said versus any other factors or evidence?
The court's record is, as the judge put it out, does not show that analysis. To be blunt with you, we both, I believe we both attached the judgment entry. It's quite short. State that, again, I can't speak for the judge or journal if it does that.
was their argument at the hearing on behalf of the state as to why reclassification should not occur?
The state did not put on evidence as such. The state frankly reviewed the report that was put on by Mr. Groom's expert. I believe that there was just some discussion in the court that some of the methodology, I believe, may have been, there may have been some question as to whether some of the methodology was appropriate, to be quite honest.
Meaning
I can't remember.
the methodology and the testing mechanisms used by the expert in this particular case.
Correct. I believe that there was at least some argument along those lines, but to be quite honest, I can't remember exactly what was said. I have not reviewed the transcript of the hearing recently, but the state did not put on an expert. We did not put on rebuttal evidence of the report.
So you accepted that he was at low risk?
The state did not accept that, but we didn't put on evidence to rebut it. We felt that, again, that was a factual determination to be made by the judge.
Well, if you didn't put on anything contrary, what's left for the court to balance and make a decision?
Veracity of the testimony given by the expert, by Mr. Groom also testified, and Mr. Groom's wife testified. Is there any other questions? I have nothing else.
Thank you. You have your full 5 minutes remaining for rebuttal, should you need it or choose to use it.
I'll try to be as brief as I can, I promise. The order just says, the court finds plaintiff's petition not well taken is hereby denied. There is no just cause for delay. That's all that it says. And we did, when he's on parole here, he goes to the state, he's going to the therapist who is designed by the parole system to treat him. So it's not like I went and found somebody. This was the same person that he had gone to, mandated by the parole officers to complete his sex offender treatment. And at that time, he was released from parole saying, lowest possible risk to reoffend. I went back to him to just ask that same person to do a refresher for this, and he came back with the same finding, low risk to reoffend. Passes, he did all the standard. I don't believe there's any question with regard to the methodology. I don't believe that came in it. And there was nothing presented on the other side, which is why this is kind of confusing, because we had this, we agreed that had it been done here, it would have been a sexually oriented offender, because had he been convicted here, it would have been sexually oriented offender, it would have been backdated to 08, he would have expired in a couple years, and he would have been what we see as tier 1 now, which is just going in once a year for, well, back then it would be once a year for 6 months. Every 180 days he would go in, he'd register, and at the expiration of time he'd be done. Now it's every 90 days for life, and we're going to send a notification out to everybody. And there was nothing presented that he could, I don't know, he can't do anything more than what he did. He testified truthfully, honestly. They're trying to do better in their lives. And there was no classification that he was a predator back then. That's not what that I'm trying to change predator findings. What happened was, because Ohio, whenever another state says, it says 10 years from the date of final release from the jurisdiction of the court. So unless you go back, because that's open-ended, Ohio views anything as predator being tier 3 now, or anything that is potentially life or open-ended as, well, that's life. So it's not like there was a finding of predator that we're asking to modify now. It was an open-ended requirement in another jurisdiction that Ohio sees as similar. The only open-ended requirement we have is the worst of it. So we just grouped him with tier 3. I don't believe that was just, I don't believe it was fair. And the testimony that was provided was not questioned in any manner or form, which was, again, I had thought maybe there would be a little discussion in an entry that we waited over a year for, and we didn't get that. So I don't know what more we could have done to put evidence on in front of the trial board. And again, I had filed that when I filed it in person, when I had filed the request that we were going to appeal this, and apparently because there was not a CV in front of the number, it was the correct case number filed in the correct civil division of the Common Pleas Court. I think they just held it. I'm not quite sure, actually. They said that they were going to fix that and send notification here. But I guess at that point, we could ask that the court remand it back for findings of fact and conclusions of law, or some type of balancing. But I would argue that that could be a possibility, but also there is nothing that contradicts anything, and that the arguments that were presented, there was no option as far as I thought that he should have been granted this. I didn't quite understand why it wasn't. So,
In the record, other than the testimony, are there documents that were submitted as exhibits on his behalf?
I believe the documents was the registration requirement through Colorado that just gave the open-ended requirement. I believe we submitted both the prior report as well as the new report, the written copies of those. He obviously was required to be brought in to testify as to those reports. I believe Mr. Groom testified as to what he's doing now and how his life has changed. And I believe his wife testified as to the philanthropic duties. The philanthropic duties that they're trying to undertake, in that some funding is being potentially held up or not given because of the new classification of the husband, and the husband was a member of
Do the philanthropic activities involve children?
No.
Or are they?
No.
Is that in the record?
Yes. The wife said no, absolutely not.
Well, these weren't child-oriented offenses in the first place, though, were they?
No.
Right.
No, they were adult massage, inappropriate touching. No, they were not anything regarding children whatsoever. If there are no further questions, thank you.
Thank you both for your presentations this morning. Court will take the matter under advisement and issue a written decision, which will be mailed to both sides, as well as posted on our website and the Ohio Supreme Court website. We are adjourned until Thursday and after.